Ladies and gentlemen, welcome to the last panel in this room. CPDP keeps the best for last, obviously, and we want to start on time so we can end on time. My name is Zerdick. I work for the European Data Protection Supervisor, and I'm heading the team working on technology and privacy. I welcome you again to the Caspar Bowden panel. Caspar, of course, had an exceptional commitment to human rights and a life dedicated to leading the way in how society can best safeguard privacy in the modern age. So I believe he would have approved us today discussing AdTech and the future of the internet, nothing less. So the issue of lawful digital advertising should have been clear since 2009, since the e-privacy directive, obviously, but we all know that it hasn't. We have learned from our IPAN workshop and from the excellent session this morning how many rampant web tracking and app tracking situations we have, and everything in blatant violation of data protection legislation. Obviously, we have seen some developments since 2009, also thanks to the GDPR-driven data protection awareness. So we've seen many official data protection complaints from civil liberties groups and individual citizens who feel they have no use from AdTech and who are actually violated in their data protection rights. We have learned about the many investigations by supervisory authorities, but surprisingly, we haven't seen many convincing outcomes yet. And some companies have started to smell the coffee. Those companies have started to announce some changes, such as Google, that they will block third-party cookies in some time, and others who have actually stopped, for example, tracking online and see their profits surge. So my speakers today will give you their views on this business model. They will share with you how they see the situation today and hopefully tomorrow. And for housekeeping, they will have 8 minutes roughly each, one after the other, and then I will open the floor to you, the audience, for your questions. And having said this, I'd like to start with Helen Dixon. Helen was appointed Data Protection Commissioner for Ireland in September 2014, and since the GDPR came into effect, the Irish Data Protection Commissioner is the EU lead supervisory authority for many of the world's largest tech companies that are headquartered in Ireland. Helen, what do you have to share with us?
Good afternoon, everyone, and thanks for the opportunity to engage with you all this afternoon. I agree with Thomas very much that AdTech is a very worthy topic for this year's Caspar Bowden panel, because it seems to me, leaving even data protection regulation aside, that it's a sector or an issue that sure is annoying an awful lot of people. I moderated a panel here yesterday, some of you might have been at it, and one of the academics on it said, look, can we even stop calling it AdTech? Let's call it what it is, surveillance tech. A New York Times October 29 article on the online advertising industry, it started off with a headline saying that the problem for that sector is that everyone hates ads. And there's no doubt a lot of people find them annoying, creepy, repetitive. They use up their data plan when they're on their mobile phone. They disrupt user experience. People feel frustrated when they're on their mobile that they're simply tricked into clicking on an ad when they clearly didn't intend to, and so on. And at the back of our minds, we know that what Bruce Schneier has said about the internet, that its business model is surveillance, that may be true. But for most of us, we can't see who is tracking us, how they're tracking us, when they're tracking us, and whether we're capable of consenting or opting in or out, and in what circumstances. So, as I said, even leaving data protection aside for a moment, it seems like an extraordinary state of affairs. By many accounts, consumers do not seem to enjoy the experience of being served with ads and personalized ads. There were predictions a couple of years back when I started as a commissioner. There were conversations being had that the industry was going to reform and change itself, not from the perspective of saying we need to regulate ourselves better, but they were simply acknowledging that their model was wearing on users and that there was going to be change. But really very little has changed. And I wonder if in part this is because of the complex ecosystems that we have. We're all familiar with that map of the ad tech ecosystem and the types and numbers of players involved. And so as I think ahead to the world we know that's very imminent and almost here now of the connected fridge and the connected cars, and we know that those experiences are going to involve embedded advertising, I start to wonder, is there no escape? Is this what we must head towards? At least at the moment you can make a sandwich or drive your car to work and not be constantly served ads. So why are we not rising up and objecting to all of this? Well, I was having a look back at Susanna Zuboff's book on surveillance capitalism, and I know not everyone does agree with her thesis and her characterization, but I think the point she makes has to be correct when she says that we're trapped in an involuntary merger of personal necessity and economic extraction, because she says all of these channels that we rely on for logistics, social interaction, work, education, they double down then also as the supply chain operations for what she calls surveillance capitalism's surplus flows. So which of us, when we're lost in a city, can resist turning on Google Maps or some other such app? One of the things that we have found difficult as a data protection authority to get a fix on, and Thomas mentioned this issue, is what the value is to online publishers and others in the ecosystem of behaviourally targeted advertising that uses these privacy hostile tracking technologies. So a new piece of research I read recently suggests that just 4% is what publishers gain versus if they were to serve a non-targeted ad. I don't know if that's true or not. Perhaps Frederik will comment on that later. But whether it's true or not, or whatever the real figure is, we're not seeing a massive swing back to contextual advertising or any voluntary resiling from the state of affairs that we have today. I think in the panel earlier that I didn't get to on AdTech, STIR did present their own use case, the Dutch Broadcasting Authority, where in collecting consent for cookies and tracking technologies, sufficient users, when offered a real choice, rejected the option, meaning that agency reverted back to contextual advertising. Let's see what the long-term impacts are. And of course, to quote Zuboff again, she said, demanding privacy from what she terms surveillance capitalists is like asking a giraffe to shorten its neck. So it seems clear we're not likely to have any voluntary action. Let me tell you just a little bit about what the Irish DPC is doing before I then go on to say what I think needs to happen in addition tomorrow. One of the things we're doing is a website sweep, and we've finished it now and are about to publish the outputs of it and guidance arising from it. And the reason we conducted that sweep, and we picked lots of different types of websites, including actually the Broadcasting Authority in Ireland, interestingly enough, and we wanted to look at how they were collecting consent, whether the consent was real, and we want to surface examples of what good looks like. There's been a lot of talk over the last few days here about the fact that different data protection authorities in the EU have issued different guidance on issues to do with cookies and tracking, which is creating confusion, I think. And this would seem to be backed up by the results of a study that I read about yesterday that involved the Aarhus University in Denmark, where they established that no more than 11% of websites in the EU are compliant in terms of the way that they're collecting consent and allowing users reject tracking. So that's one thing on the website sweep, because if we had a starting point where there was real consent collected and there was respect for the rejection by individuals of tracking, we'd undoubtedly be in a better place. Then we have actual statutory investigations ongoing. One of those is into Quantcast, on foot of issues raised with us by Privacy International. Quantcast is a data broker. And of course, data brokers are a significant element of the ad tech industry. So we're looking at how the data is sourced in relation to Quantcast, what transparency there is to users, given that most of it is not directly collected by Quantcast from the individuals, what the lawful basis for processing is, whether there's profiling, sharing, and selling of the data, and in what circumstances. So that's going to be part of the jigsaw. We also have an investigation open on foot of issues raised with us by Johnny, Ryan and Brave, and Johnny's of course on the panel today. So it's an investigation into Google and the real-time bidding system. So we're looking at what personal data is being broadcast and to whom in the bid auctions, what the lawful basis is, the transparency, the necessity and the proportionality. And we've a range of other investigations then open on foot of issues raised by La Quadrature du Net and None of Your Business around the Apple advertiser ID, around LinkedIn, and around online behavioral advertising on Facebook. So lots of individuals looking at individual big platforms and looking at specific issues. One of the things I was talking to Johnny about earlier today, however, is we will conclude those investigations. Some of them will conclude this year. Most of them will conclude this year. But there are always going to be limitations, I think, in terms of the output of investigations. And what I mean is that they have to, investigations and the analysis and the legal analysis we conduct against the facts we find has to track to the law as it's written. And if we look at some of the recent CJU judgments, as an example of the point I'm trying to make, like Fashion ID or Planet 49, I read a lot of commentary to the effect that people were disappointed with those judgments, not in the sense that the court didn't, of course, correctly apply the law, but in terms of where it brought us to. There was an expectation that, oh, when we get the answer to the like button, the Facebook like button in the Fashion ID case, then we'll fix a lot of things and we'll know a lot more. Or in the Planet 49 case, there was an idea perhaps that the court might comment not just on what consent exactly should look like and what the form of affirmative action should look like when a cookie is being dropped, but that they might go on to say, but these cookies shouldn't be dropped at all. But of course, that's not where the court went with them. So let's see where the investigations bring us. Let's see what they add up to in terms of what is a jigsaw. But we do have to remember there are thousands of data controllers in the ecosystem. So once we resolve these issues and conclude in relation to the specific controllers, there will have to be actions taken against further controllers.
Helen, thank you very much. And I'm sure there's one who's particularly interested in the outcome of that investigation. That's our next speaker, Johnny Ryan, Chief Policy and Industry Relations Officer at Brave, a private web company. And I'm sure, Johnny, you can tell us a bit about real-time bidding, the GDPR, and your view on that. Thanks.
Thank you very much. I'm going to stand and pace, much to the consternation of the AV team. And I'm going to try and set, I've got a clicker. I'm going to try and set the table for a conversation about real-time bidding. So I'll go through the basics of how it works and then maybe talk about what the future might look like. So let's start off with what probably everyone now is familiar with. You visit the Daily Bugle, a newspaper. Information about you is sent out in a bid request to several auction houses, known as ad exchanges, to solicit bids for your attention in milliseconds. Each of these exchanges then sends this information on to tens, maybe hundreds of other companies known as DSPs, And the logic is that the right brand at the right time will make the right bid for the right person's attention, and the correct ad will be shown. Now, there is something clever about this. The idea is that the publisher is maximizing the number of people who see the inventory, who see these eyeballs, and can make a bid for their attention. So in the short term, the publisher should get a great win. It doesn't work like that in reality in the long term. Here's the problem. The problem is that once the data are out from the website, once they are gone in a bid request, in this broadcast, there's no control over what happens to them. There's a complete absence of security. So let's take a look at one DSP that we know about. This is Vectory. It was investigated by CNIL, the French regulator. CNIL found that Vectory had, I think, over 5 million people's data through a location SDK that it was providing to other apps as a component for those apps. But also, it had 67.6 million people's data by sitting in on this exchange system. Now, in case you can't see this, let me make clear, Vectory is a tiny company. No one had ever heard of it. 3.5 million turnover in the preceding year. They're a minnow. And somehow they had almost 70 million people's data from real-time bidding. There are thousands and thousands of Vectories. Now, when you go to Vectory's website, you see this remarkable claim. It's in our DNA. We believe in privacy. We're about privacy. And actually, there's something to that claim. They're better than many of their colleagues. When you scroll down the page, they've got some good privacy claims. They say we only keep 30% and we dump everything after a year, which if you're good at your maths, you're thinking, does that mean that they actually had 250 million people's data from the RTB system? CNIL will know the answer. It's actually immaterial, but it gives you a sense of the scale of the problem. So let me show it to you a second and final time. Many of you have seen this slide. Together, we're going to do something very courageous. We're going to load a web page using a browser that isn't Brave or a combination of other tools, and we'll slow down the process. You, poor victim, load the page, editorial content is served, and then a process that begins this broadcast of your data starts. Now, this is assuming just one ad exchange, not several. And the focus of our complaint is all of these yellow arrows emanating from initially the publisher, but really from the ad exchange. That's what we're focused on. Now, the question then is, why is this a problem? What is in those yellow arrows? So let's take a peek at what might be in these yellow arrows. We can know with some certainty because the industry makes public how the system works so that the thousands of companies who work within the system know how to build their tech. So we've got the Google system, we've got the IAB system. These are the two rule books. Let's take a look, because Townie's here, we'll put her on the spot. Let's take a look at the IAB system. Now the IAB system says, someone from Google just laughed when I said that, by the way, that's not good. The IAB system says, okay, you can have 595 different types of data in a bid request, many of which I think are benign. No problem with them. But let's take a look at a summary example. So this is from their own documentation. You would use these documents to know how to work in the system. So at the top, we've got what this person's looking at, in this case, the domain, but very often the entire URL. Here we've got very specific identifiers about this person, far more specific IDs than you would have in your social security number. They may not last as long, but they are highly unique. Now we've got the fact that this is a young lady, and we've got a whole lot of stuff about her device, including IP address and so forth, so that we can find her again and guess if we need to. And it always amazes me, remarkably, we have where this young lady is standing, her GPS coordinates, right, in the IAB system. So this is a problem. How big a problem is it? What's the scale? Let's think of one of these auction houses. Index Exchange is its name. Its marketing material claims, they would, but this is what they say, that they process 50 billion bid requests every day. So This to me sounds like it's the biggest data breach of all time, except that Index is one of the smallest of the big ad exchanges, and it gets bigger and bigger. So when we're trying to think about how much data is being leaked all over the place, the focus here is the absence of security. How much data is being leaked all over the place? We're dealing in billions and maybe trillions. And it suggests that this is the biggest data breach of all time. And the upshot is that every single person you've ever known, everyone you could ever know who's alive today and is on the internet, it is entirely possible that very sensitive things about them are being broadcast out to thousands of companies for unknowable purposes right now. And this huge data breach cannot be rectangled away. There is no degree of magic to a rectangle, no matter whether it says OK or accept, that makes this problem go away. The finest example of a consent notification that I've seen, and I've seen a lot and analyzed most of them, the finest one came from a professor, some of you will know him, Christopher Hoofnagel at Berkeley. When you go to Professor Hoofnagel's page, this is the consent message you get. It's a very good consent message. It says everything you need to know. It says everything he's able to tell you about what will happen to the data, because nobody has a clue. So not only would you not be able to give your consent to a data breach, I would not be able to ask for it because I have no idea what's going to happen to the data. So the issue, let's step away from accountability, transparency, fairness, proportionality. The issue is security. If we look at the industry's own documentation, it is there in black and white. Thousands of vendors can get the data from a single transaction. There is no technical control over what happens to those data. There's no way to have that technical control that I'm aware of. In the update, we have a claim similar to Google's impossible claim to be able to audit the thousands of companies receiving these data without any investigatory powers and figure out what they're doing with the trillions of pieces of data that they're receiving probably every week. And the ICO seems to be content with this gesture from IAB UK. We, at the end of your 6-month act or die warning, we have convened a work stream. So we're at a point of no action. In Google's case, yes, they tell people don't misuse the data, but then they tell people you must regulate your own misuse of the data if you plan to misuse it, right? You must notify us if you're going to break the rules. Now, this is what happens to regulation when it walks into a bar and meets some other self-regulation and they have an inbred child. This is self-regulation of self-regulation. And what the regulation actually says is, you're not allowed anywhere near the data unless you can keep it safe. It says that for very good reason. And what we have in the industry is the opposite. It's the old idea of broadcast from before radio. A farmer puts his or her hand in a deep, container of seed and throws it to the wind, which is what a bid request is. Now, here is a problem we have in the market. What we need is enforcement of security, but if we have enforcement of security, some people may fear one big company may wrap the entire market within itself and solve the security problem, but create a monopoly. Now, that's assuming the market does not have certain harms. I'm about to wrap up. I realize I'm about to filibuster. We have a problem, external and internal, two sides to the problem, and purpose limitation is the beginning of the answer for the internal one. Let me, before I sit down, as I slowly walk back to my seat, talk about the future market. It's going to look something like this one. Everybody was happy with this thing. We love these things. We would drive these until the world burns. But the negative externalities are so catastrophic that eventually we had to change. And this thing that lost 100 years ago, that people said was inferior, came back. And we're going to have, of course, a situation where some of these things are worth keeping. In this case, classic cars. Now, that is exactly, I think, what will happen in our data market. We have this problem where we're used to this model of broadcast of personal data. This is what happens. There's a possibility for my colleagues at the IAB and Google perhaps to strip away these bid requests and have a slightly safer, hopefully a much safer RTB system. You could also have, I'll skip ahead here, you could also have what we have at Brave. If people opt in, you build a profile on the device, and the device receives ads, but it does not broadcast what the hell is going on the device, and we as a company do not know. And before I shut up, let me talk about results. The industry uses a pretty poor metric to calculate success. We've been testing this approach for 6 months, lots of campaigns, and we have some figures to share. The industry uses a figure called click-through rate. If you take a look at Google Display, Facebook Display, and Google Search, you see the normal figures. These are Brave's figures for opt-in, completely private ads. It's a totally different ballgame when you actually use privacy to make good business outcomes happen. Thank you very much.
Thank you very much, Johnny. So you're saying there is hope, and there is a market. Now I wonder what Simon Hania can tell us about this. Simon is the data protection officer at Uber, and he's heading the global team that independently advises on and monitors Uber's compliance with the GDPR. Simon, a DPO in that company on that panel. Please.
Thank you. So what I wanted to do with you is talk a bit about what it means to be a data protection officer in a context like this. And I want to do it a bit more broadly than just Uber, because I've been data protection officer in other companies with similar issues. And maybe that can help to also arrive at conclusions if or how a DPO could be part of the solution, whatever that is. Now, before I go into that, it's pretty clear, of course, that the problem here is of a wider nature than just simply complying with law. It has been called a systemic problem. Systemic problems require systemic solutions. So we need to pull much more power to this than just the DPO telling what you have to do. So let me go a bit into that. So what's important for me as a DPO, I'm a purist as a DPO, I would say. So I take GDPR, which means that I am a guide, a watchdog, and an ambassador. I don't run the privacy program. That's the controller. That's the advertiser in my case that runs it. So that's an important element here. But I do need to take, of course, the individual front and center, observe, conclude, and maybe even judge, and then report out to, in our case, executive leadership. It also means that I will not be reporting out to you as a user. I'm not going to do that today, let's be clear. But I want to tell you how this works, so you can understand it and see how we can forward that. So one of the things you do as DPO is you ask a lot of questions when you're confronted with a situation. One of the things I've done recently, but also previously, is go out to the marketing people and first ask them what actually makes you tick. Why are you there? What is the problem you solve for our company? And what is the problem you have? Get an understanding of that. And there's two things that struck me. The first one is that marketing used to be an art, and now it's become a science. It's become very factual, very measurable. It used to be the marketeers that initially had to market themselves to management to get budget in the hope they would get a return on their investment. These days, it's called performance management, and it's very, very well measurable if your marketing organization has matured. That's not the case in every company. But that fact in itself also allows to be injected into arriving at the solution. And that's needed because there's one other element I learned from the marketeers, is that they are completely scared to change things if they can't predict what the change would result in. They need to be convinced that their return on investment will be as good or even better. Now, we've seen some signals just now, this morning from Ster in the Netherlands, that there is hope. But we need to move that beyond hope and move it into expectation and business cases. So that takes time. it takes engagement with these marketeers to look at that. It also means that at a certain point in time, and I'm getting back to the role of a DPO, initially having a view of this, all of a sudden realize this may be a point in time when I have to start speaking truth to power. Let me unpack that for you, what it means in this context. So if you want to be speaking, you need to make sure you are listened to. So first, you need to establish yourself as a DPO as being someone that people want to listen to. If you think that through, it takes quite some effort. You may not be in the right position. You may not have the right mandate. And actually, little gritty legal details may actually prevent you from having a mandate, because e-privacy doesn't recognize the DPO. And by the way, as a DPO, I also have an escape, because in the recitals of the GDPR, it states that I should focus on the core processing activities, and marketing is an ancillary activity, so I don't have to deal with it. Of course, you should do that, but that could be thrown against you. You just need to make sure you're not struck with that. So that's being able to speak. In order to speak, you need to have a message, and that message better be very truthful. It requires facts. So we've seen some of these pictures. These are all simplifications. They may be different in your business. You really need to go through it, understand it fully. That takes time, it takes effort, and you need to be very specific and precise, because the stakes are high. What you also need to be able to do is then arrive at your independent judgment. It requires an understanding of these laws and how they interrelate, and how data protection authorities would look at them, because in a way you're a proxy of the data protection authorities, and by the way, the other authorities involved. That is also not easy, because there is a lot of phrases like likely, or could be, or there's even conflicting. So it means that you need to take the courage as a DPO to take a position where the data protection authorities have taken a position or have conflicting positions, and then confront your senior leadership with that message. That requires courage to do. So then you may have arrived at the truth, but then you need to understand, where do you deliver that message? Now, it may very well be that that message has to be delivered to an executive leadership team. It could also have to be delivered to a supervisory board. I myself sit on a supervisory board of a few NGOs and foundations, and it is not easy to talk to people in their 50s who are not a digital native on this topic and what it means to convince people. That's also part of that game. You may also be confronted with other regulatory authorities who start to get uncertain about the fact that their rumor has it, AdTech is an issue, so you may be violating GDPR, so that may require us, the other regulator, to revoke a license to operate. The case we saw this morning from the Dutch public broadcasters advertising arm, to me is an example of that. It is, of course, inconceivable that a publicly funded, partially advertising funded broadcaster would engage in violations of the GDPR. So there was an external pressure. So how to build that urgency, because importance is easy, but the urgency for the company to start to act. Organizations need some pain to start acting. Now, that pain could be inflicted by data protection authorities in the form of a ban on processing, in the form of a fine, but there is a bit of an interesting situation developing, because as it seems that in some cases as an advertiser I'm suddenly a joint controller. So now I'm not established in Ireland. I'm established in the Netherlands. How will this unfold? Will there be a joint operation? I don't know whether there has been a joint operation ever, the Article 64 out of my head. To a DPO, that creates, again, uncertainty, so it takes courage to advise your company to go there. So, to cut this long story short, There are a lot of elements that need to be put in place for a DPO to be able to step up and speak up. That's why I'm also happy to be here, to be supported by all of you, to help making the change. But it cannot be a change with one company. It has to be a change across the industry. Because when you sat down here, you noticed this chair is too close to me. You may have moved it. That's effectively what we need to do with advertising, because there is no doubt in my mind that advertising is relevant, is necessary in the economy, but maybe it should be a bit less close. Thanks.
Thank you very much. Indeed, so change is here. And we have Townsend Feehan with us. Townsend is the CEO of Interactive Advertising Bureau Europe. And I hope she can share with us which changes we'll be seeing and if there is still a business model or if there should be. Clicker is here.
Clicker. Thanks. I actually have 3 things to manage. Here, that may be too much. Thank you. So thanks very much for the possibility to be here. It's a very nice opportunity for us. I would like to take, as quickly as I can, to overlay the law on the alarming scenario that Johnny laid out. I would like to speak for the perhaps it is as few as 11% in the survey that Helen evoked, the ones who are conducting data-driven advertising in a legally compliant way, because for the moment the standard is the law, the standard is the GDPR, and our mission must be to comply with the law. And I would like to bring that dimension into the discussion. So it's pretty clear digital advertising falls within the scope of the GDPR. We have a very broad definition of personal data in the European Union that's almost anything under GDPR. We have the e-privacy directive, even pending adoption of a new regulation. We still have the old directive. GDPR has extraterritorial application. So anyone anywhere on the planet targeting a user physically sitting in the European Union is in scope. So it's self-evident that this activity must comply with the law. Our position is that the best way to achieve that, first of all, that it can be achieved, and the best way to achieve it is for companies to comply with a transparency and consent framework that we put out now, whose first edition we put out now 2 years ago. So the TCF is an open source cross-industry standard with multi-stakeholder governance. It enables first parties, what we call first parties, so any website that interacts directly with the user, to obtain a GDPR legal basis or consent for e-privacy access on behalf of the third parties that don't have the direct relationship with the user. It's a rules-based system with standardized information disclosures that align to all the requirements laid down in Article 13 and 14 of the GDPR. It has harmonized data processing purposes, which ultimately not only make the interaction of the user with the site possible and easy in the moment, but will over time have the effect of educating users, helping users better understand to what data processing activities and for what purposes they are being invited to give their consent or elect not to object. It has minimum requirements for UIs, so there is not a fully standardized or fully harmonized approach to the UI, because the UI is the place where the website, publisher or other website is interacting with his user. That is a privileged relationship, which we wouldn't want to be overly prescriptive about, but we have minimum requirements that ensure that those UIs align to the requirements of the law as we understand them right now. Obviously, it's a bit of a moving game. A standardized signal, digital signal, that enables accountability amongst the parties. So accountability, the possibility for users to hold data controllers accountable, the possibility for data controllers to hold other data controllers accountable. Perhaps most importantly, or it seems relevant today, enables auditability of by enforcement authorities, by DPAs and other authorities. And it is the way that my industry can deliver on the core promise of the GDPR, which is transparency, choice, control, granted to users, in exchange for which personal data can be processed legally to deliver services of value. This is an image we use to describe the framework because it's abstract and hard to make concrete in words, but it basically consists of the UI that I mentioned already, the TCF policies, which are the rules of the road, rules that the websites implementing the framework must follow, technical specifications that make sure that those rules are actually reflected in the implementation, and a global vendor list, so a pool of companies to which any website using the framework has access, bounded by the rules to which I referred earlier. So that's just another visual representation. We got version 1.0, which was essentially a consent tool, out 1 month before the GDPR came into force in 2018. And version 2.0 was published in the summertime, end of August. Version 2.0 reflects quite a lot of feedback that we got from DPAs and the market on V1 in 2018 and 2019. It has more granular purposes that give users more control and better meet the standard of specific and informed consent. It has clearer, more user-friendly language. It's very difficult to reconcile, obviously, the requirements for simplicity and specificity, but this is a second-shot attempt. It has a concept of stacks, which are kind of high-level terms that capture a number of purposes about which the user must have detailed information in the next layer. Information is easily accessible, so we have tougher requirements in V2 about which information has to be in the first layer, being the layer available to the user before they're able to consent. Integrated right to object functionality, because we've added the legitimate interest legal basis in V2 to the consent legal basis that was in V1. Separate opt-in control over precise use of precise geolocation data and active fingerprinting. This has animation that I don't actually have time for, but these are the purposes in V1 on the left and the purposes in V2 on the right, which just shows you that we have added that greater granularity and specificity. In V2, I don't know how to go back. Obviously, a standard is of no utility unless it is seen to be enforced. For the moment, this is a voluntary standard. It's not yet a code of conduct. We aspire to have it endorsed as a GDPR transnational code of conduct, but we haven't made that application yet. We started a compliance checking exercise in summer of last year. First stage was self-checking by the CMP, by the consent management providers, which are the kind of connecting tissue between the website and the user, and the vehicle by which the user expresses their choices, and the agent that then communicates those choices throughout the rest of the ecosystem. First stage was self-checking. Second stage was submission of the results of their self-checking to us and a verification by us. We certified 130 CMPs by November of last year, because each of those had shown us a compliant UI in a staging environment. That certification was conditional on rollout of compliant UIs across all properties that those CMPs work with. That rollout has not been complete. It is variable, and whether the 11% statistic is the right one or not, it's absolutely evident that there is not uniformly compliant implementation of the framework, of the requirements about the framework UIs. And that is something that is must urgently be addressed, and we are doing a phase 2 checking that is currently underway, even though the whole V1 is going to be deprecated in the next 2 or 3 months, and everybody will, so in theory, in fact, the more important standard is V2, but we will do the same kind of compliance checking for V2. So very quickly, I'm sure Helen is tired of hearing that there are these differences from one jurisdiction to the next. DPAs, small discrepancies or big discrepancies emerging. I think the discrepancies are opportunistically overstated. I actually don't think there is blue water between the ICO, the CNIL, other DPAs that have come out with updated cookie guidance recently. But the perception that there are differences from one market to the next complicates our task of encouraging uptake of the standard. I get the observation that perhaps the TCF policies are too demanding. They go beyond what's absolutely been ascertained to be required in the law. And so that is something that undermines my efforts. We suffer from the fact that DPAs, there is no mechanism for the DPAs to informally say something warm and encouraging about our framework, because the mechanism that is contained in the law for that kind of endorsement is a carefully prescribed code of conduct application. Anything short of that just kind of doesn't exist. Just for clarity, we certainly don't advocate that websites or the internet be funded exclusively by advertising. Advertising should, however, be an available revenue stream. There's no reason for it not to be. All revenue streams have some can occasion conflicts with respect to independence of editorial control, and the best portfolio is a mixed portfolio. Users do need to have the possibility to decide which services they pay for and which ones they are prepared to consult and fund by being the object of advertising based on data of which they have full transparency and visibility and control. Advertisers want accountability and attribution measurement, and some big, powerful companies with a lot of data sets may be able to do attribution measurement or frequency capping without processing personal data, but that will not be available to everyone in the ecosystem, certainly not to a lot of small publishers whom we're trying to support. And I think it's self-evident that a healthy third-party ecosystem enables publishers to better compete with the scale of the logged-in services whose ability to offer audiences to advertisers is just part of the furniture.
Townsend.
Yep, sorry.
Thank you very much. I hear there is change somewhere in the system, but I wonder if you could have convinced Frederik. Frederik Borgesius is with us. He's professor ICT and law at Radboud University Nijmegen. He teaches law to computer scientists. And let's hear from you. You've been nodding, sometimes not nodding. Tell us what you think.
Thank you. Good afternoon, everybody. I'm first going to make a depressed remark, and then I'm going to try to make a few optimistic remarks, because otherwise we leave CPDP not in the right mood. So I started my PhD research on behavioral advertising in 2010, and I just, while sitting here, realized that's 10 years ago. And the situation back then was shocking. And as we saw with Johnny Ryan's presentation, it is still, and I'm a pretty cynical person, but still after 10 years, this still shocks me. It's incredible that you visit one website. And I checked this morning even one of my favorite websites, The Guardian, 15 trackers, you refresh the page, half of the trackers are different, so the information you read the first time doesn't explain what happens after one click. It still shocks me. And I'm not going to list all the ways in which this breaches not only the GDPR, but the rules that we had before already, but the most obvious one is the complete lack of transparency. It's just completely impossible to explain people what happens there. I can imagine 3 tracking companies, 3 advertising networks that some super good designer could explain that to website visitors, but this is beyond explanation. So far the depressed remark, like 10 years and still it becomes worse and worse actually. Then gonna try to be a bit constructive. I'm usually a bit skeptical about rational choice thinking, but we saw the GDPR is adopted and only the threat of fines made a lot of companies work harder on compliance. So that worked. The GDPR already didn't solve everything. Laws rarely solve everything, but GDPR has good effects already on our society. However, threats with fines have to be credible. It must be credible threats. And if there's not enough big, serious fines in this sector, then the original threat that, of enforcement that the GDPR had is not taken seriously anymore in this sector. And as Johnny Ryan showed, apparently many players in the sector don't take the rules very seriously, otherwise this wouldn't be happening. So far this was depressed and me trying to be constructive, namely heavy enforcement with serious fines that also scare companies that have billions of, not turnover, billions of profit, like some US companies. Even the 50 million fine of CNIL won't really scare them. And now a short-term optimism remark and then a long-term optimism remark. Let's hope that the e-privacy regulation will be adopted soon in a version close to the European Parliament version. There were some good ideas in that. For instance, a full ban on tracking walls. That was an easy rule that you can easily comply with. There's not much wiggle room there. That was a good idea. And a pretty smart idea if you think it through. So the e-privacy regulation is, by the way, a kind of internet privacy cherry on top of the GDPR. And there it said, I'm summarizing here, do not track and similar signals for all parties that see such signals, it should be required to comply. So that means that in your browser you tick, I don't want to be tracked. Everybody, all these tracking companies see that your browser says that, just like a website and other tracking companies see that you're on an Android phone or a Safari user or whatever. The law should make it required to respect such signals, backed with serious fines. And those two measures together, make compliance with do not track required and a ban on tracking walls, could perhaps mitigate this enormous data breach that we saw. And then for the longer term, but this is me really being optimistic, in the Internet of Things, etc., wouldn't it be lovely if there's a kind of do not track signal that we can send around with our phone? You walk around and all the billboards and all the fridges and wherever tracking will happen for service improvement or advertising or whatever, all these billboards should then see, this is one of those persons that doesn't want to be filmed. This is one of the persons that doesn't want to be the victim of Wi-Fi tracking, etc. But let's not build that into the current e-privacy. Perhaps we should build that already in the current e-privacy regulation. But this is more a function that we need in the somewhat far future. And then I'll quit because I'm eager to hear what the audience has to say.
Thanks for these thoughts. A bit depressed, a bit hopeful. I'm still scratching my head that this is a problem we know about. We thought we had regulated since 2009. If we can't, in Europe, deal with digital advertising, how are we going to lead on AI? So now it's your chance in the audience. If there are questions, I'd like you to step up to the microphone in the middle. I'd like to collect some questions first. There's one. Please state your name, your background, and if your question is to whom or to the panel.
I'm an Austrian non-student anymore. I have a short question. So I'm the head of an NGO, and we have a, as you called it, legitimate revenue stream, which is donations. So to do that, we basically have to find people that are really caring about privacy, which I understand you do. So to get you to donate for us, I would like to have your IP address, your birth date, your geolocation, your device ID, your gender, and all the web pages you've visited, so I can target you that you donate to us. And I would do that based on legitimate interest. Would you agree that I can get all this data from you right now and that that is my legitimate interest? Because you mentioned the IB thinks that there's a legitimate interest in all of this? Or may that probably be a situation where your rights override my rights to target you for my legitimate revenue stream? Thanks for answering the question.
Thanks, Max. The question is to Townsend first, or to all of us?
Just a colleague from the IB.
Okay.
Yeah, well, I'm not sure. I mean, so there's a paradigm where I would make a donation, and there's a paradigm where you would target me to solicit a donation. I've been, so I think it's not really an exact parallel to an advertising scenario, but I mean, I'm in complete control under the GDPR to grant consent, to exercise the right to object, to withdraw consent, to provide you data, to not provide you data, to find out what data you have about me, to ask that you stop processing the data you have about me, to ask that you correct the data you have about me, to move the data you have about me to another supplier. I mean, there's quite a lot of options right now.
Can I have it right now in the law? You haven't answered the question.
Can you have what?
Yes, thank you.
So
I think she tried to answer the question, and I prefer to go and give the floor to the next member of the audience. Please let us know who you are and to whom your question you ask, please.
can I just finish? I mean, if you were an organization that I had a relationship and trusted, presumably I would have no issue in providing the information. I mean, you had a long list. I don't know what else is going to be in the et cetera. But
Sorry. We need the microphone. So please, if you have further questions, you can step to the microphone again, but there is a gentleman. Lukas?
Hello. So, first of all, I would like to highlight that I am speaking obviously as a concerned citizen. So, I would have a small intervention and a question to the CEO of Internet Advertising Bureau. So thank you very much for walking us through the fascinating marvels and details of transparency and consent framework. This is actually very, very interesting to encode this directly in cookie. But and I appreciate that you also guided us how it interacts. It supposedly interacts with GDPR. It's not for me to decide. Supposedly it interacts with GDPR and e-privacy. However, I wonder, why do we focus on TCF and GDPR, since these are the developments from 2018? I think TCF has been released in April 2018. However, I know from my research, and I did one of the first privacy and transparency analysis of real-time bidding, which I did since 2013, so I know that this system, in fact, operates for very, very long, and of course it evolved over time, but when it comes to the principles, it works the same. However, at the same time, we did still have this data protection directive, which in the essence of security of processing and purpose limitation is mostly the same, maybe even exactly the same as GDPR. So would you consider pre-TCF real-time bidding as compliant with European Data Protection Directive?
Okay, so long question.
yeah, well, I would just say, first of all, I completely agree with you that the structure of the law hasn't changed that much, from the 95 directive to the GDPR. And then I think that there has been legally compliant behavior and non-legally compliant behavior, either, both under the 1995 directive and since the enforcement of the GDPR.
Okay, thanks. Any thoughts from the panelists on this? If not, I give the floor to the next.
Hello, I have a short question, mainly for Johnny, I think. Because you mentioned the example of Vectory, which I think is really good. How do you think, or what do you think about the fact that Vectory was not fined? The sanction issued by CNIL was that within 3 months, the company was supposed to come into compliance with GDPR, which supposedly they did. So how would you comment that? Because we are discussing, and also in the earlier panels about AdTech, the lack of real enforcement, and as Frederik mentioned, the fear of fines is actually not there. And although Vectory is a very good example of enforcement, it's not fines. So what do you think about that? Thank you.
It's a while since I've looked. It's a while since I put that slide together, so Vectory is a blast from the past. My answer won't be particularly well polished. My problem with the Vectory decision was that it was about Vectory. And had they, the CNIL, and I've said this to them, had they asked Vectory, not, hey, we've noticed you have all this data, had they asked them, where did you get this data from? Then we would have gone up to the SSPs and to the ad exchanges, and they could have actually had a transformative effect. Now, what I've heard from people at CNIL is, well, we were learning and just getting started, so we took a discrete little thing and we kept it simple. Maybe there's some merit to that. Maybe there is, I don't know, but I was expecting they would follow up with something more significant. This ties into this broader question about enforcement and the effect it can have. One thing that I think there's an emerging consensus about is that focusing on fines is to focus on the wrong thing. We've learned with antitrust enforcement that the fine, if it's a course of doing business but does not change business, may just be kind of a tax one has to pay. And the real power for regulators is to go into companies, ban the data processing and force deletion of the data. And with that in mind, remember that our colleagues from STIR, who I've been talking to for years about this problem, the reason they were so interested in leaning into the law is that their national regulator had been making their lives a misery for 10 years. NPO was never out of the papers, as you would know, and as you would too.
Thank you. Next question.
Thank you. My name is Robert Riemann and I work for the European Data Protection Supervisor, and my question goes to the representative of Brave and IAB. And I wonder how you deal with the consent in case of children browsing the web. What are your ideas on how you can make sure that also children understand the purposes and the functioning of the system in order to make a decision?
I have to say that, so the Transparency and Consent Framework itself doesn't have any child-specific provisions, and organizations that are processing data for the purpose of digital advertising or content personalization that are operating in my industry would need to comply with the relevant provisions of the GDPR and I guess national requirements with respect to what constitutes what the age limit is for a child.
I think for nearly every company, this is something that should be agonizing and is just ignored because it's a hard one to solve. The brave approach is do not at any point have personal data about the data subject at all, right? Don't be involved in it being processed. If someone were to use Brave and were a child, and if they were to opt into the ad system, there still would be no one processing their personal data. It would not be happening. But here's the problem. If they, this is where we get into Brave's particular niche, if they were to receive a basic attention token payments from seeing ads in the Brave system, for that child to cash out into real currency, they would then need to go through a know your customer process, and they would at that point be rejected. So we have tackled it. I don't think we've tackled it as smoothly as we should have. And for every company, it's a real problem. We're lucky that actually it's not it's not a big problem for us. But I would hate to be working in a normal company that actually had a different approach to personal data.
Thanks. Helen?
Yeah, could I come back in, Thomas, on that interesting question earlier about Vectory and whether a fine would have been applicable or not? I mean, without being the Keneal and being inside on the analysis, it's very difficult for any of us to second guess. But I agree with what Johnny said. The important thing is that was investigated, the issue identified, and the corrective measure applied, and that is likely to be more effective than the fine. But just a couple of things to mention that we haven't so far. Lots of you will have seen that Ken Bamberger et al. Paper that he published recently, where he did the study of almost 6,000 Android apps, looking at the paid and free versions. We've had this narrative now for so long that it's this access to free services for which we then pay with our data that's the issue. And actually what that Ken Bamberger paper now shows is that the paid services that we think, because we're paying and we don't see ads, are not tracking us, that they are doing exactly the same data collection, data sharing in at least half of the cases that were analysed. So one of the things that I think is very important here is enforcement is going to be part of it. The Irish DPC will finish out and indeed start new investigation cases in relation to the issues raised. But there are thousands and thousands of controllers, and enforcement has to be case by case. Vectory was mentioned, but as Johnny said, there are thousands of Vectories. So we're not going to get round to investigating everyone and fining them all, but where the enforcement will play a role is that it will clarify how we say the law applies, and it will start to serve as an example and as a precedent. But there's still going to be a gap, because we have the narrative wrong, according to Bamberger, in terms of what our understanding is, because the paid services are also presenting a problem. And we also have a gap. Simon said earlier that, of course, what Johnny had to present is a simplification, and that's absolutely true. We don't have all the facts. We still don't know server to server what's transmitting, because as DPAs, we've got to get in there. So I think this is a massive, global, billion-dollar industry, and enforcement will play its part. Data protection enforcement, Simon also said there's more than data protection involved, and that's also true. But we shouldn't knock on its head the idea of expert roundtables and other fora being necessary to drive forward our understanding of this industry and what's going to be needed to resolve it.
Thanks. Is there another question from the audience?
May I just probably explain my further question before again? I was not talking about consent. We all agree that if everybody really consented, it's all fine and good. I talk about legitimate interest. And my question is, we do advertisement too as an NGO. We do that as well, just like the IAB members. Do I have a legitimate interest to get your phone's data, just like the IAB members do? Ronnie Ryan has shown that there are thousands of companies that I've never heard of, never had any relationship with, that do have my personal data. We had the Grande complaint. If I use Grande, they know I'm looking for dick at a certain time. That's what your members do. Do I have that right, or don't I? And that's a legitimate interest question. I think it's very interesting that you jumped that a bit, said, yeah, there's legitimate interest too, because it's very, very crucial for the ad industry sector. If the default is they can all spy on our phones, and if the EIB endorses that, or if you say, no, it's a consent-based system, which is a very different story. And that is, I think, a very clear question. There are only two answers to it. Either it's consent, either there's a legitimate interest, or it isn't. And I think that should be answerable.
Okay, I'm not sure it's so simple and clear, because you mentioned Grindr and some other scenarios as well. So let's take a charity that I give money to. I give money to the World Wildlife Fund. If I'm asked online by the World Wildlife Fund for whatever reason to provide my phone number, I'd be likely to provide my phone number, and I would probably accept that the World Wildlife Fund takes that information on the basis of a legitimate interest, that their lawful basis for that processing that information would be a legitimate interest. I have a reasonable expectation because I have an existing relationship with them, and so that feels to me as if they would pass the balancing test taking my phone number. Does that answer the question?
No, because you don't answer about the 1,000 other people that I don't have a relationship with.
Well, then you can't, 1,000 other people whose existence you don't even suspect, you can't possibly have a reasonable expectation about, therefore the legitimate interest legal basis would not be operative.
Thanks for that answer.
Thank you. And
Can I make
yes, Simon.
So, an observation on this conversation is that it's highly technical, both in IT and in law. And in order to get to a better place, all of us, we also need to be able to voice this to other audiences. We need to be able to make business leaders understand there is a problem, why there is a problem, and what the solution could be. And it doesn't help if we stick in our privacy bubble, hammering down on data protection authorities. We need to raise the topic elsewhere. What I found fascinating, actually, is that the moment there's a Chinese app company allegedly doing similar, all of a sudden there's another level of attention and maybe things start to happen. What I also find interesting is that when competition authorities, like for instance the UK CMA, have been looking into one of the social networks in discussions on interoperability, let's not go there, I don't know what it is actually, but there's other regulators also starting to have an interest. Why are they having an interest? How does that relate to what we think in our privacy bubble as we're sitting here? We need to open the windows and make others part of our conversation, but also learn to talk their language. Because we can have, and that's a very appropriate discussion on legitimate interest, but the rest of the world really doesn't understand what that means and why it's relevant. Yeah. That would be my plea.
Yeah, thanks. Simon, I take these as your last words for this panel, and I want to give the opportunity to the other speakers. How can we come to a better place in this issue? Let me start again with Johnny, maybe final words.
Let's come back to this idea that there are thousands of factories and that it's unreasonable to expect that we can have enforcement against each and every one of them. We know that we don't have well enough resource DPAs, right? That's a fact. That's a fact in nearly every member state. I want your job. So it's a fact. The member states have failed the GDPR by not adequately resourcing the DPAs. We know this is true. In some cases, there are training issues too, depending on the member state. So, in the case of AdTech, it's actually, in a way, a lot like the financial industry. It looks incredibly complicated, a spaghetti work of arrows, but it's actually surprisingly simple. There are two, and this is a case we needed to make, there are two bodies that set the rules for this data breaching system. There's the IAB and there's Google. Now, I remember we had to make the case to the ICO and convince them, we have a record of that, that in their case, the IAB is the data controller because it set the rules. And that means you don't need to go after the vectories. You can go after these two entities that control the whole system.
Thanks, Johnny. Helen, any final thoughts? Brief?
I think we need to get to the facts. I think we need to build that broader understanding. We didn't talk also about the issues today that every time you talk about making a big change in ad tech, you hear the argument that small publishers will be the ones that you lose out, and that ultimately the platforms with their first-party relationships will always win, and so on. So there's a huge complexity to the ecosystem. I think we need to get to a point of better understanding. I think DPAs need to enforce and will enforce. As I said earlier, it's not going to be the full picture. I think some of this idea that the US is having a constitutional moment may yet get to a federal privacy law is going to help. I think Tim Berners-Lee and the work his foundation is trying to do to agitate for a new and better internet, all of that is going to contribute, but we have to open our minds and ears and not be focused on a narrow track of if only they would do this, it would all be solved. It's a little bit more complicated.
Okay, thanks. Townsend, one sentence.
Maybe I think the perhaps moving away from looking at just sanctions, perhaps a positive, proactive encouragement by the academic community, by regulators, by influencers, thought leaders in the industry to help the industry converge around at least one legal standard, legal compliance standard that's trying to make it in the market would help.
Okay, thank you. And Frederik.
Let's hope that in a few years we can focus on other topics because the worst problems in this sector are solved. And thank you to the audience.
Well, thank you very much. And can I please ask the audience to join me in giving a hand to our speakers?